Today, we are going to be continuing our discussion of a very important issue in the Brian Walshe case. This issue is the issue of the Google searches. Now, we already understand, if you've been following the Brian Walshe case, how incriminating these Google searches are for Brian Walshe. Well, the defense filed a motion to suppress all those Google searches, and they want all of these Google searches to not be admissible in trial. And the Commonwealth responded. There was an evidentiary hearing, and right now the judge took this under advisement. In the last video, we discussed the idea of consent. Now, we have to understand that when the police discovered these Google searches, there was no search warrant. Yes, they executed a search warrant a little bit later, but at the time that they discovered these Google searches, there was no search warrant. That's a strong basis for the defense to move to suppress these Google searches. So what possibly could be the argument back from the Commonwealth or the prosecution? Well, the first argument that they made, which we discussed in the last video, was that Brian Walshe consented. If a person consents for the police to search their home or their devices, then there's no problem. They don't have to get a search warrant. The search warrant is only if you do not want them to search your house, then you have a protection. You have a Fourth Amendment right for that, unreasonable searches and seizures, and therefore you can make the police go get a search warrant that shows that they have probable cause to search your devices or your home or whatever it is, and then it's not going to be considered an unreasonable search and seizure. Well, in this case, you can argue that there was consent because Brian Walshe, after all, turned over the devices and said, go ahead, go have at it. Enjoy. But it wasn't actually that clear because a lot of times there are consent forms which people sign before they turn over the devices, which shows what the scope of the search is going to be and what you're consenting to and what you're not consenting to. Well, in this case, there was no consent form. There was an email back and forth with Brian Walsh's attorney on a different case on the federal matter. And there is some ambiguity. You can definitely argue that there's some ambiguity in exactly the scope of the search. And the defense is arguing that Brian Walshe only consented to the searching of his devices for communications, nothing more, not Google searches. And therefore, if there's any sort of ambiguity as to what the consent was, that weighs in favor of the defendant. And actually, that's what the case law stands for. So if the Commonwealth just wants to use, the prosecution just wants to use the argument that there was consent here, they may actually lose. And some of these Google searches will not be allowed in trial. And again, these are very, very incriminating Google searches. So today we're going to concentrate on another argument that the Commonwealth made, and that is based on the inevitable discovery doctrine. And that doctrine is the following. If the police are going to inevitably discover something, then even if they got a hold of that information before they actually had the search warrant, but they're inevitably going to discover that information, well, then it's not going to be considered fruit of the poisonous tree, and therefore you still will be able to admit these searches in trial. Now, speaking about digital footprints, I think we should pause for a moment and talk about your digital footprint. And that is thanks to Incogni. Incogni is going to protect your digital footprints. Every time you sign up for a new service or make a purchase online, your personal information can end up in dozens of databases you've never even heard of. Phishing and spoofing were the most prevalent types of cybercrime reported by elders in 2024. They reported a total of 23.3 thousand times, a 700% increase year over year. Investment scams had the highest loss to report ratio and were associated with losses amounting to $1.83 billion, or a staggering $194,100 per complaint. Let Incogni protect your hard-earned investments and protect you from phishing and investment scams. Use my code BROTHERCOUNSEL, all in caps, at the link below for 60% off an annual plan. The link is also in the description. Okay, now that you're all going to take care of your digital imprints, now let's talk about Brian Walshe's digital imprints. Now, but we have to jump into a little bit. We're going to pull up some of the motions and responses that were filed, and we're also going to play for you a part of an evidentiary hearing, which is very important. Now, the idea is that if the police were able to show that there was some other reason why they had to search those devices, then they can argue this inevitable discovery doctrine. So let's walk through some of the Commonwealth's arguments here, and we're going to have to take this motion apart piece by piece, which is what we're doing. But this is how we get to where we need to for the Commonwealth. All right. So this is from the second recorded interview. There was 4 interviews that Brian Walsh gave with the police at his house. This is taken from the second interview, January 5th, 2023. The defendant said that Anna was up early and kissed him goodbye at 6 a.m. before she said goodbye to their 6-year-old son, who was already awake. This is January 1st. It was a Saturday, I believe. He described what he thought Anna was likely wearing and the bags she carried. He had not seen Anna leave. He got up and made breakfast for the children around 7 a.m. This is all talking about Brian. When Robin, the nanny, arrived at 2 p.m., he went to Shaw's for groceries and went to Swampscott to see his mother around 4 p.m. He said he went to Whole Foods and CVS on the North Shore before returning home. Now, if any of this turns out to be incorrect, if he's lying to the police and misleading the police, that in itself is a crime. And if that's a crime, then the police can go perhaps execute search warrants in furtherance of that investigation. And if in furtherance of that investigation, they search the devices and it turns out they find this other incriminating information, well, then you can argue inevitable discovery doctrine. You see how this works? When even though they would technically be searching these devices for something else, for a different crime, but it doesn't matter. Once they find those searches and it points to him committing a different crime, they're able to use it. So again, this is what he's telling the police, that he went to Shaw's for groceries, Swampscott, Whole Foods, and then CVS. Continuing, he explained that he did not have his phone until his son found it in a bed, and so waited until Wednesday to call people and said he should have probably started earlier. When he found his phone, he called Anna on Monday around 2:30 or 3:30 p.m. and left a message. Listen to the message that he leaves. You can call. It's been a while. You've had some rest. I don't know what is going on. That's his first message that he leaves his wife, who he hasn't seen in a couple of days and haven't heard from in a couple of days. Okay, interesting. All right. So now that is what he said. Now let's go down to further. A lot of this we did already in the last video, so we don't have to go over it again. I just want to focus on what's relevant for this specific argument. Continuing, the defendant unlocked his Volvo SUV for police who saw a January 4th, 2023 receipt from Lowe's Home Improvement in Weymouth and iPhone in the center console of the car. The carpet had fresh vacuum marks, and the plastic disposable liner that had been observed the previous day was not present. Detective Sergeant Schmidt asked where that liner was. The defendant pointed to the garbage area. The defendant said that on Monday, January 2nd, so Sunday, was January 1st. I said Saturday. I apologize for that. So the defendant said that on Monday, January 2nd, he took his oldest son for ice cream in Norwell while the nanny watched the younger boys. The defendant did not have his phone, so he could not text the nanny, who looked through the household trash for the phone. Now, they later discovered that he actually did have his phone at that time. So again, they're finding a lot of things where he's misleading the police. But the question is, how did they determine that he was misleading the police? How did they find that out? We're going to see in a moment. Later that afternoon, Trooper Keefe determined that the iPhone had been manually unlocked on January 1st, 2023, at times when the defendant had claimed it had been misplaced, and noted location data for January 2nd, 2023, showing that the phone had been at Home Depot in Rockland from 4:12 p.m. until 4:56 p.m., as opposed to being at Press and Norwell for ice cream with his sons, as he had told investigators at the January 7th interview. Now, let's pause for a moment. Okay, how did he determine this? How did Trooper Keefe, who was Michael Proctor's partner, but not in this case. I mean, now in this case also, but okay, Michael Proctor is already done. But how did he determine that Brian Walsh was lying? And he determined this from the download from the phone. Okay, so this is the initial download, which, if there was no consent, was illegal. So therefore, any argument now from the defense that whatever Trooper Keefe found on the phone, and that's what they're going to use to charge Brian Walsh with anything or use for any additional searches, That's all improper. That's all fruit from the poisonous trees, because the defense's position here is that any of this downloads that they're finding, the extractions, the Celebrate report, all of that, and the location data, which is included in that, all of that, it falls under the fruit of the poisonous tree doctrine. So it cannot be used to then go ask for further searches or conduct further searches. So that's not going to be helpful. But let's continue. Now they have a fourth interview, recorded interview number 4. Attorney Minor had receipts from places that the defendant visited on January 2nd, 2023. We have Press, which we told you about, Shaw's, which I think he told you about, and Shake Shack. On January 8th, 2023, police obtained this search warrant to search the defendant's residence for, among other things, electronic devices, including the 3 that had been extracted and searched with his consent and then returned to him. So this was on January 8th. The defendant was arrested later that day for misleading police. That was what he was initially charged for. Misleading the police, meaning lying to police, telling that you were doing things that you weren't doing, that you went to stores that you didn't go to, that you didn't have your phone when you really did have your phone. And they did get a search warrant. This is a search warrant, January 8th, 2023. But again, if that search warrant is only based on the information that they got from the cell phone, then the defense is going to have a strong argument here. But we're going to see why the Commonwealth may actually be saved here. They may be saved by one thing, but still, it may not be so clear. So let's see. On January 9, 2023, police sought individual search warrants for the contents of each electronic device seized from the house. And this is search warrants 39 through search warrants 46. So again, January 8th, they had the search of the house. They got the devices. And then you had, and these are the same exact devices that were extracted previously with under consent. If according to the Commonwealth, they thought they had consent. And if the defense is arguing they did not have consent, well then any information that cannot be used. But now they're getting additional search warrants for misleading the police. And now they actually got these phones based on a search warrant. Okay. Now, this is some of the consent arguments that we already went through, a lot of it in the first video, but now I want to concentrate on the other part. So let's just get down there. Long motion, by the way, if you want to read the entire thing. But let's get down there. Oh, long motion is right. Here we go. Okay. Separate from the consent search of the devices, the information found on the devices would inevitably have been discovered. The 3 devices searched pursuant to the defendant's consent were returned to the defendant before the extracted data was examined. These devices were inside the house on January 8th, 2023, when this other search warrant was executed at 516 Chief Justice Cushing Highway, and were seized by police. Police obtained separate warrants to search these devices and re-extracted them. So in case you thought they relied on their initial extraction, no. We got search warrants, we re-extracted them, and now we should all be good, right? Well, not necessarily. Let's see. Before examining data extracted from the devices with the defendant's consent, and again, that is the defense's argument that there's no consent. So before that even, police had probable cause to charge him with misleading police. As review of surveillance video confirmed that he had not traveled to the Swampscott Whole Foods or CVS and made purchases for his mother, as he repeatedly told the police when he described his activities of January 1st, 2023. So this is what the Commonwealth is hoping is going to save them. That because before they even knew anything that was on these devices, even if you want to say that there was no consent, but they still found out information independent of what these devices had on them, independent of the information on the devices, they found out for themselves, just based on their own investigation, that Brian Walsh was lying. So again, if police had not examined the iPhone and 2 iPads with the defendant's consent, they would have inevitably discovered these devices upon issuance of search warrants authorizing police to seize the devices and search them in connection with the defendant having misled the police. Now, you know me just a little bit. You guys know me by now. And that is that something that I just don't love about this paragraph is that there is no citations at all to any case law. And if this is what's going to save the day for you, you got to beef this up with some citations to case law, telling us about the inevitable discovery doctrine, showing how other cases are similar to this case and why, in this case, the doctrine should apply. Okay, so something that's missing, glaringly missing from this motion. Now, let's see what Lieutenant Fanning has to say about why they went to search, how they ended up searching the surveillance from those, the CVS and the Whole Foods. Give me one moment. Let me pull it up here. Okay, here we go. So listen carefully what he's saying, and when they found out what information and whether they can make an argument that they had no idea about what was in those devices before they discovered this other crime of misleading the police, and they were able to discover that without any information of the devices.
Now, later that afternoon, were any of the troopers assigned to your detective unit dispatched to the area of Swansea?
We're talking January 7th.
January 7th, yes.
Yes, they were.
Okay. And to be clear, we're talking about Saturday, January 7th. Who was dispatched to that area of Swansea?
At approximately 4 p.m., I dispatched Trooper Kukowski, Sergeant Panazelis, Trooper Gobranson, and Trooper Sullivan.
Where did you send Trooper Kukowski?
CVS in Swansea.
Why did you send him to CVS in Swansea?
Because Brian Walsh had told Trooper DeChico and Detective Schmidt that he had went there when he visited his mother.
And where did you send the other 3 troopers, Gobranson, Sullivan, and Pantazelis?
Whole Foods in Swansea.
Why did you send them to Whole Foods in Swansea?
Because the defendant said that he had went there when he went to his mother's residence.
And so why are you sending troopers to these locations that the defendant said he was at?
To confirm if he went there.
And so that was done. Those troopers were dispatched on Saturday, January 7th at approximately what time?
Between 4 and 5 p.m.
And
January 7th, 4 or 5 p.m. That's when he sent these troopers to those locations where Brian Walsh said that he went to see whether he actually went there. They looked at the surveillance camera to see whether he actually showed up there. So that was January 7th. He sent them between 4 and 5 p.m. Now let's listen to when he heard about the report, the extraction report.
That time frame, when was it that you heard back from Trooper Kukowski about the CVS in Swansea?
I'd say somewhere in the 6 to 7 p.m. range. I can't recall the exact time.
And what was it Trooper Kukowski able to confirm as far as the defendant entering the CVS in Swansea?
He was not there.
And was Trooper Kukowski dispatched to another CVS at this point in time?
Yes.
Which one?
I don't recall exactly. And that wasn't at my direction. That was something he did on his own, which would be normal for investigators.
And did you receive knowledge from Trooper Kukowski if he had discovered the defendant on video of another CVS to confirm his timeline?
Yes, and he did not see Brian Walsh at the other CVS.
Now, going to Whole Foods, who was sent to Whole Foods?
Sergeant Panazelis and Troopers Sullivan and Gobranson.
And what were they able to discover as far as confirming the defendant's location at Whole Foods as he related to Trooper DeChico?
He did not go there either.
And about what time were they at Whole Foods to discover this?
Somewhere after 5 p.m. on the 7th.
Now, when were you ever notified about the contents of the devices that were given to Trooper Keith on the 6th?
Around 6 p.m. on the 7th.
So you heard that. That's when he found out about the devices, about the search from the devices, all these incriminating searches. He didn't find out about them until after he already sent the officers to these other places, the Whole Foods and CVS, to see whether Brian Walsh's story lined up, and it didn't. So they knew all this information. According to Lieutenant Fanning on the stand right now during the evidentiary hearing, they knew about all this misleading the police before they knew anything about what the devices and all these Google searches said. And the location data, by the way, also. So they weren't using location data. They weren't doing anything from the extraction of the devices in order for them to just do their investigation to confirm whether Brian Walsh was telling them the truth or not.
And who notified you as far as the contents of any of the devices?
Trooper Nick Moreno.
Okay. So that's essentially really what the testimony was. So this is what the Commonwealth thinks is going to save them from the argument that even if there was no consent, well, it was going to be inevitably discovered. Why? So the argument is that, well, we had this other investigation. He was misleading the police. If it's misleading the police, well, then we have rights based on the misleading the police investigation, and we can execute search warrants based on that for his devices. And once we have his devices, well, then if we find other incriminating Google searches on them, well, then we can also apply them to other crimes that he may have committed. So what's the defense's argument to this? Well, they actually have a pretty decent one. Okay, so let's take a look at the argument here. These are the search warrants as we went through. This is 39 through 46. This is where the defense is talking about these search warrants. So they're talking about the affidavit that was presented by none other than Trooper Michael Proctor, former Trooper Michael Proctor, to get these warrants. So let's go to the next part. Okay. Members of the Massachusetts State Police traveled to Home Depot to obtain any possible video surveillance based solely on location data illegally obtained from the defendant's phone. Said travels to Home Depot revealed the defendant purchasing various items such as mops, tarps, tape, and a Tyvek suit. Now, we spoke about the Home Depot search, and that was we didn't hear from Fanning that anybody went to the Home Depot. So this was potentially only based on the devices that the search from the devices that they got, which showed them the location data. And then they went to pull the surveillance footage. So this is not going to be as good of the argument as when it comes to CVS and Whole Foods. But let's continue. Officer experience. People who commit crimes together often communicate. However, there's no evidence or suggestion of any co-conspirator. So the question here is, okay, let's say you have somebody who's misleading the police. Does that mean that you can search anything that you want now of the police? Do you have no more Fourth Amendment protections at all? Of course you do, right? There has to be some sort of nexus between the crime and what the police want to search. So one of the things that Michael Proctor said is, well, we should be able to get his devices because people who commit crimes together often communicate. So therefore, who knows? Maybe Brian Walsh, who was misleading the police, was communicating with somebody about that. Well, there is no evidence or suggestion of any co-conspirator. Next, people often communicate with their victim prior to or following the crime. And here we go. Well, Anna Walsh is the defendant's wife. It is expected that they communicate. So in case there's arguments there that he was communicating with Anna Walsh, well, she's his wife. Now, these search warrants requested permission to completely search various electronic devices, namely iPhone, iPad, and MacBox. In an effort not to repeat himself, the defendant directs the court to the arguments in Section A, Item B from Addendum A above. The defendant will take the opportunity to highlight the government must demonstrate a nexus between the alleged crime and the device to be searched or seized. Search warrants relying on the ubiquitous presence of cellular telephones and text messages in daily life or generalities that friends or co-ventures often, I'm saying that word right, I'm sure you'll correct me in the chat if I'm not, often use cellular telephones to communicate are insufficient to establish the nexus for a search of such a device. And again, while an officer's experience is a relevant factor, alone it cannot furnish the requisite nexus. So what they have right now, the police have without searching the devices, is they have a missing person and they have misleading the police, potentially. But then the argument is going to be, well, what nexus does Brian Walsh's phones have to do, or his devices have to do with either misleading the police or the missing person investigation? Those are the only two things that the police can know about without searching his phone, which they argue was without consent. And therefore, the defense is arguing here that even if you're going to try to use this inevitable discovery doctrine, it's still not going to work because there still has to be a nexus between the criminal conduct and the search that you want to do. So that is where we are left today. And again, like we said, the judge took this under advisement. We have not had an order on it yet as I'm making this video. Who knows how soon the judge will get the order out, but we are still waiting to hear about this. And this is going to be, like we said, an incredibly important issue in the Brian Walsh case. If these searches do not come in, his chances of acquittal really go up. And again, it would be unfortunate if some troopers dropped the ball here and didn't cross their T's and dot their I's into this investigation. And because of that, you may have somebody who would have been proven guilty, but now if you cannot provide these Google searches as evidence or admit them as evidence, you'll have a problem. So that is where we are left right now with Brian Walsh's case. So we will see what the judge eventually orders. Will be an opinion, I'm sure, We like to go through the opinion. It might be a lengthy opinion, but we'll take it apart and try to break it down for all of you. And that's going to be it for now. So if you haven't yet, please subscribe and like, and we will see you next time.